無論你係新移民定係老華僑，打工仔定係老細，只要你係住喺安省同埋未退休，你就要知道有一條法例叫做 Employment Standards Act ESA。ESA 係安省嘅勞工保障法例，涵蓋咗福利、假期、解僱同人工等項目。不過唔係每一個細節 ESA 都可以涵蓋到。就一個案例，我哋邀請咗安省勞資法律師李冠瑩律師嚟解答。僱員使唔使對公司或者客戶財物嘅損壞負上責任呢？
And first of all, thank you for having me here. I'm very happy to share some information. And thank you for letting me answer in English. That's a great question. So the question is, is that employee liable for the damage that they caused to the company property or the client's property? And the starting point is no. In most instances, the employee should not carry any liability. Rather, the liability should rest with the employer. And let me explain why. So what this employer is going through, there was an accident, there was damage, and now there are some expenses and costs. The courts have recognized that that is simply at law treated as a business matter. It's a business issue for the employer. Okay, it's for the business. It is the employer's business to run. It is their business risk to bear. And as a result, if the risk does materialize, then any business expense is for the employer to deal with on their own. And they could deal with that either as a cost of doing business, right? They can pay out the expense, or by making sure that they've got the appropriate insurance coverage. And it's not relevant if the employee is a new hire under a probationary period or a long-term hire. It is the employer's responsibility to make sure that they have the insurance coverage. In contrast, our laws have said that an individual employee, they're not in any position to be able to absorb this kind of a risk or this kind of a cost or buy this kind of an insurance. And in fact, that's why they're an employee for a business rather than going out on their own to open up their business and taking on the risks. So what's happened here, it's unfortunate. I'm sure nobody is happy about it, but at law, this is a business risk and liability issue. It is not the employee's legal liability to bear. There's some exceptions. It's very rare where if an employee caused damage due to fraud or intention, like it's an intentional harm that they did to the property, causing harm. There may be some ways for the employer to say, hey, maybe the employee should take on some liability, but that's very rare in very rare circumstances. And the employer's onus, like the threshold for them to meet that kind of a test is very high. So hopefully that answers your question.
公司有冇權從僱員嘅人工中扣除賠償金，或者要求佢哋直接俾錢？
Yeah, so consistent with what I've just said, the answer is correct. So the employer really has no legal right to make any deductions like that. So most employers, most businesses in Ontario are governed by an important piece of legislation in Ontario. Okay, so it's called the Employment Standards Act. This is the minimum standards legislation, and we call it the ESA, Employment Standards Act. The ESA very clearly says that an employer can only deduct from employees' wages things like taxes, statutory withholding, so like CPP deductions, EI benefits. If there is a court order, okay, so if there's an order from the court saying they're allowed to deduct, or if an employee has a signed written consent allowing for the deduction. Otherwise, the employer cannot make any deductions, not even in situations such as they feel like an employee has taken too much vacation and owes the company vacation pay. You can't do that. And very specifically, the ESA says that an employer cannot make deductions to an employee's wages due to faulty work. Okay, so the statute or legislation has already built in protection like that. So here, this employer cannot deduct the $4,000, whether it's lump sum or by installment, nor can they demand repayment. So what I want to add is, clearly there was an accident. Clearly there are damages, right, resulting to the customer's property. In other instances, it could be the company's property, and the company, this employer now, they've suffered some harm. So I do want to add, what can an employer do? Okay, so they can't go after the employee for this repayment. Well, they can still discipline an employee, right? So if the employee's done something wrong, maybe they didn't follow the best practices, maybe they made a mistake in the process of doing their work, the employer can discipline them. They can issue a warning letter, they can put an employee on suspension with or without pay. And in very serious situations, there could be a termination, right? And these are very complicated concepts. The employer will have to talk to a lawyer about what to do, what can they do. So I just want to be clear. It's not that the employee has zero responsibility. It's just with the $4,000, the level of liability is different.
僱員可以點樣避免類似情況？例如，有邊啲公司政策或者合約條款係需要留意呢？
Yeah, it's hard to say whether or not all of them are invalid. The best way is really just to remember what I've said as the general laws. As employees, my recommendation is always, if you have been given an employment contract or an offer letter, it's best to just get a lawyer to review it with you, so that you understand, what is it saying? How does it impact my rights and my responsibilities? What do I have to do? What is this contract saying that I have to do? And an experienced lawyer, a good employment lawyer, they should be able to tell you all of those things, but also, whether or not there's red flags. So any problem, any cautionary comments that you need to be aware of, so that you can really protect yourself. That's really the best kind of scenario for an employee to protect themselves.
喺安省可以點樣揾律師協助解決勞工問題呢？
Yeah, so there are many ways to find a lawyer. It could be by referral, by word of mouth. Oftentimes that probably is a good way to start. It's not very possible to cover all the ways to find a lawyer, but once you have a few names and you're meeting the lawyer or talking to the law firm, it's not uncommon for the law firm to initially have a consultation, and through that first meeting, it would then be sort of your way to decide whether or not you feel comfortable working with the lawyer. And I would encourage everybody to shop around, like basically make sure that the lawyer is someone who you feel like you can comfortably work with them, you can trust. Definitely ask about how they collect fees in advance, so that you go in, how much it is that you're going to spend or how they're going to bill you. There's no set formula or method in terms of how lawyers here collect legal fees, but generally speaking, they're the ones who collect a percentage of any outcome, any damages award, and that's called contingency. Okay, so it's a contingency arrangement. And then there is the other type where the lawyers bill hourly. And so as a result, as a client, you would pay on an hourly basis. Typically speaking, in employment, it is possible that you have employment lawyers charged by the percentage. So you don't usually pay a lot of money up front. You wait until the lawyer takes the case through to a resolution. And then depending on how much is recovered, then the lawyer will take a percentage that you and the lawyer have already agreed upon in advance. Okay, so in Ontario, this is usually in the range of 25% to 35% of your recovery. So if the recovery is $1,000, it's usually in that range, 25 to 35% of the $1,000. If it's $100,000, it's the same math. However, I wouldn't say most of the lawyers do that in Ontario. There are many other types of legal matters, meaning reasons why you would go see a lawyer, not always because of a lawsuit. And sometimes it just doesn't make sense for a contingency fee arrangement. I would say more common than not, law firms will charge on an hourly basis. In my personal opinion, in my practice, a good lawyer, a trusted lawyer, should be able to tell you in advance that, look, a lot of these cases, they're unpredictable, right? You don't know exactly how long it's going to take, what are the complications that will happen. But there is a general idea, a general guideline as to these are the steps that's required. Step 1, step 2, step 3. Step 1 should be around this amount of time, and I need to spend about this many hours during this step before we go to step 2. And then step 2, typically it's around this amount of time. I'm expected to spend this number of hours. And so that at least you have a budget of legal fees in advance. So again, in my opinion, if you can find a lawyer who's able to at least give you that kind of a guideline, rather than just, okay, hourly, right? And who knows, it could be like 2 hours, it could be 200 hours, you don't know. So I would basically make sure that you talk to the lawyer and make sure you're comfortable with that. So those are sort of the general tips that I have about when you're looking for a lawyer. Hopefully that answers your question.
歡迎提供一手新聞材料，報料一經採用，你可以獲得10蚊 TNT 或者 Amazon 嘅禮品卡。可以透過以下嘅電郵、WhatsApp 或者微信相關嘅影片同資料俾我哋。